Thank you. So, is it agreed that the committee proceed to clause-by-clause consideration of Bill C-45, an act respecting cannabis, and to amend the Controlled Drugs and Substances Act, the Criminal Code, and other acts? Is that agreed? Agreed. Shall the title stand postponed? Shall clause 1, which contains the short title, stand postponed? Okay. Now into clause 2, which I will pick up from, it starts with the interpretation section. I will pick it up from page 2. And let me get my amendments out here because I've got the first of the amendments. And the first of the amendments, well, the first two amendments are the same. How about that? But I understand Senator Dean will withdraw his, so TD1, consider that withdrawn. And in its place is CP, CP standing for Chantal Petitclerc. It is number 1, and you can find this, it's in clause 2, which is on page 2, and then on page 5. There's 3 components to it. I would ask, you want me to read it?
No, she can read it.
Oh, you can read it. You can read it in either language. So if you could tell us what the amendment is and why, and as short as possible. Thank you. Merci. En français.
I propose that Bill C-45 in Clause 2 be amended by A, replacing line 13 to 15 on page 2 with what follows. Presented to be used in the consumption of cannabis, and B, replacing line 17-18 on page 2 with the following. Represented to be used with consumption of cannabis. C, replacing lines 28 to 30 on 5 with the following. A thing that is commonly used in the consumption of cannabis is deemed to be represented in the use of consumption of cannabis if this amendment comes out of the Agriculture Committee, and I would like to thank the Senators Black and Griffin for their concerns on this amendment. The amendment seeks to remove apparatus or items used in the production, agriculturally speaking, of cannabis. Industry representatives since cautioned us on this issue because mostly they're gardening type of materials, fertilizers, soil amendments, etc. And these in the definition of cannabis, if we remove it from the definitional clause, they can feel secure in selling them with information that this pesticide can be used in the production of cannabis. Now, these preoccupations were put before the Agriculture Committee, and various provinces and territories also had the same or similar concern. So we're dealing with the consumption of rather than the production.
Questions or comments, Senator Stewart-Olson?
I do have a question. I'm not clear on the agricultural amendment. Does that mean you can use fertilizers and maybe toxic materials on the cannabis, and that's okay?
Well, the fertilizers are used in the production of cannabis, and they are regulated under the Pest Control Products Act and the fertilizers, so they are regulated that way. And right now what is happening is that they are part of the definition of accessories, and what the industry is telling us is that it really restricts them in terms of where they can sell those products, and they want to be able to sell the production the production products of cannabis with being able to say that this can be used for the lightening of cannabis or for the growth or for the pesticides of cannabis.
That's fine, as long as it's regulated. I just wasn't sure.
Yeah.
Okay. Senator Seaman, you have a question too? Or that's it?
No, that's fine.
Okay.
Yeah.
Anything else? Can we agree to this? Is this agreed? Carried. So I now have, I don't have any other amendments to clause 2. So I need to know, shall clause 2 as amended carry? Okay, on division, is it? Okay, I'll consider that to be on division, majority in favor. Shall clause 3 carry? On division, carried. Shall clause 4 carried? On division. Clause 5, we get to clause 5, I have more amendments. I have JS1, that's Judith Seaman number 1.
It's actually to create a new clause, 5 point.
It's
So
to
clause
create,
5 can carry, you can ask. There's no amendments to clause 5. This is to create a new.
this, I'm being advised, this is to create a new clause so that in effect, we can carry, if there's no other amendments to clause 5, we can carry clause 5. Is that agreed? Carried on division, everything's on division, I'll say. Okay, so, anyway, so we have the amendment from Senator Seidman to create a new clause called 5.1. And it's, do you want to read it and give us the why on it, please?
Well, just to give you a little bit of background, I mean, this has been discussed at our committee and as well as Legal and Constitutional Affairs, and it has to do with not applying harsher sanctions to youth and to adults. So the issue has to do with the Youth Criminal Justice Act. And in fact, we had a question to the Justice Department on Friday when we were here, and we asked them if this law specifically provides protection that we're looking for youth. And it's not written in the law, and they seem to be deferring it to the provinces. So we said to them, well, then what's the harm of writing it in the law? Is there any harm of writing this guarantee in the law? They didn't seem to find any harm. So it was Pascal Levesque, actually, the chair of the Committee on Criminal Law with the Barreau de Quebec, who clarified that nothing in Bill C-45 should limit the operation of the extrajudicial measures that are provided for under the Youth Criminal Justice Act, which would encourage the use of warnings and referrals instead of criminal sanctions for youth caught with over 5 grams of cannabis, up to a certain limit, of course. And, you know, she said very clearly, it says to all stakeholders that the police community officer would have that in mind. So before stepping over to criminalize and stigmatize, the principles, the scope, and the objective of the YCJA would be applied. And that's the whole point of this amendment. So it is proposed to amend the bill to provide that no harsher sanctions be applied to youth than are applied to adults. And thus, Bill C-45 should be amended. I move that Bill C-45 be amended on page 6 by adding the following after line 8. 5.1, for greater certainty, nothing in this act is to be construed as limiting the operation of the extrajudicial measures that are provided for under the Youth Criminal Justice Act.
Any other comments on this? I'd like to ask the officials. I'm not certain whether this doesn't have some challenge for doing what you want to do. So can I just clarify that with the officials? Whether it's justice, I guess, in this case? Yes.
Thank you, Mr. Chair. Just to be clear, when I did receive the question on Friday, and I think my answer was that there could be unintended consequences, and it is to the following effect. Rules of statutory interpretation direct courts when they're interpreting and applying the law to say what was in Parliament's mind when they adopted this section or that section in a bill. Part of our answer to begin with was that Section 5 of Bill C-45 already says very directly, explicitly, the Youth Criminal Justice Act applies to the offenses committed here involving young persons. There's no doubt, uncertainty about that. So to add the proposed motion clause, then a court applying usual rules of statutory interpretation would say what was in Parliament's mind when they adopted 5.1, and how is that different than what's in Section 5 now in Bill as C-45 as before the committee? And all I can say is, while there's no intention, I assume, to create a different approach, I think that might be part of the natural discussion and interpretation of two very similar clauses. What was the difference in the first one that isn't addressed and that needs to be addressed in 5.1? So the harm is potential unintended confusion because of statutory interpretation.
But the beginning of this says for greater certainty. Doesn't that tell them something? It's not contrary to the previous Section 5, but it's saying for greater certainty. Doesn't that explain it better? You're not sure.
I don't really have anything more to offer,
okay.
other than I think if you look at other laws of general application that are criminal in nature, it's not, and the Youth Criminal Justice Act will apply no matter. It's not usual in other laws where you would say specifically, this law, under this offense, this law, if a youth is the accused, then the Youth Criminal Justice Act applies. Bill C-45 does do that here exceptionally, to be clear, because the offenses are a little bit different when you are dealing with youth, with different penalties, including when the youth is a victim. So there's an intention to be very clear, for sure, with Section Clause 5 that's in Bill C-45. All I can say is that what more or what different does 5.1 add? That would be the question.
Okay, Senator Seaby.
Yeah, I would just like to add that this amendment actually comes from a unanimous recommendation from Legal and Constitutional Affairs Committee that studied in pre-study the legal and constitutional issues associated with this legislation, heard from many, many witnesses, and this was a unanimous amendment. It was nonpartisan, supported by every member of the committee. I think that's important to understand.
Doesn't mean it's right legally, but
No.
anyway. Okay, is it agreed, or is it agreed to have this amendment? Agreed. Agreed? Okay, carried. Next I have, on page 6, this is also a new clause 5.1. If this actually gets carried, it would be a clause 5.2, I guess. 5.2. But I want to point out something else. Further down the line, on if you look in your amendments, page 23 in your amendments, there is an amendment, a JS amendment, JS 6. And the latter wording here is much the same as this wording, but it has some other wording. It talks about possession of cannabis as well. How can we marry this up here?
JS 6.
JS 6 on page
It might be 25.
6. JS 6 has very similar wording in one respect, but has additional wording in another respect. I just want to point that out. We can deal with that when we come to it, or you can try to marry them now. Okay, when we come to it? All right, so this one is, this one is in the name of Senator Petitclerc.
Président, je propose de...
Thank you, Chair. I move that this clause be amended on page 6 by adding the following after line 8. 5.1, well, 5.2 perhaps. For greater certainty, this act does not affect the operation of any provision of provincial legislation that is more restrictive with respect to or prohibits the cultivation, propagation, or harvesting of cannabis in a dwelling house. Now, this amendment comes directly from Legal and Constitutional Affairs Committee, a recommendation which was carried there unanimously. And which only recognizes that provinces have the authority to authorize or prohibit the dwelling house cultivation of cannabis, homegrown. Members of the Legal and Constitutional Committees, in regards to, has worked diligently on this, including Senator Dupuis and Senator Pratt. This particular issue of homegrown cannabis has been discussed quite extensively, particularly in Quebec and Manitoba. Quebec does support this amendment, and our committee did accept it, the motion that is, unanimously. There's another amendment a little further on, it'll come up again. The reason we decided to present this initially in the application portion or application portion of the law, in Article 12, Clause 12, there's another discussion on that production, but in consultation with our legal experts and our Senate specialists, we decided that it would best be placed under the rubric of application for the results sought. I'll be prepared to answer questions if you need further detail. It's fairly straightforward.
This is the one that would give, for example, Quebec and Manitoba the opportunity
Absolument,
to
oui,
say
c'est
zero.
celui-là. C'est l'amendement.
Exactly so, Mr. Chair. This authorizes or recognizes a provincial authority to prohibit homegrown cannabis.
Senator Seaman?
I would wholeheartedly support this because it's clear, as we discussed last week on Friday with questions to the various departments, that they would not necessarily proceed to prosecute a province if they had prohibited home cultivation. However, undoubtedly, a private person would. And at that point, the federal government would become an intervenor in that court case, and then would become a conflict between provincial and federal jurisdictions. So it should be clear in the law right now, and so I would wholeheartedly support this recommendation.
Okay. Any other comments? Okay. Are we agreed on CP11? Agreed. Okay, that then becomes 5.2. So we've adopted 5.1 and 5.2. We've adopted the rest of 5. So shall Clause 6 carry? On division. Clause 7 carry? On division. Okay. Now we get into the 15 different parts of the bill, and it is agreed with leave that the clauses be grouped according to the 15 parts or divisions of the bill as described in the table of provision of Bill C-45 when appropriate. Is that agreed? Agreed. Carried. Okay, so Part 1, Division 1. Part 1 is prohibitions, obligations, and offenses. Part 1, Division 1. Division 1 is criminal activities. And the first amendment I have up on that one is JS2. And it relates to page 7 in the bill. And Senator Seidman.
Yes, so I'll give you,
One other thing. There is this, depending on what this happens with this amendment, it has consequences for 3 others. It has consequences for JS3. JS5, in fact, is actually the main amendment. I don't want to confuse you too much on this, though. And also JS11. These are all consequential amendments that depend on the outcome of this one.
correct, I should say that that would be the law clerk in the Senate who developed the amendments based on the proposal that this amendment deals with. So in fact, you're right, it's 1, 2, 3, 4 amendments. Okay, so The committee heard evidence from witnesses on our own committee and the Standing Committee on Legal and Constitutional Affairs that home cultivation of cannabis plants is inconsistent with the government's objective as stated in the bill to protect the health of young persons by restricting their access to cannabis. It also renders the product tracking system proposed in the bill close to useless and provides opportunities for organized crime to supply the additional market. Home cultivation increases exposure among children and teens, poses a fire hazard, damages housing stock by causing excess moisture levels, and increases the likelihood of burglary and home invasion. Police and municipalities have said unequivocally that the 4-plant limit is unenforceable. So, I will also suggest to you that CAMH, the Center for Addiction and Mental Health that Senator Dean has put forward, and their report has put forward their report as a model for this legislation, has said that home cultivation should not happen, that it is unenforceable. Benedict Fisher, he's the author of the CAMH report, and he's categorically opposed to home growing of any kind, saying we categorically believe that this is a misguided portion of the law. So I can give you many more quotes if you'd like. Okay, the current bill includes, this is another quote from Benedict Fisher, senior scientist at CAMH, when he appeared at Legal and Constitutional Affairs. The current bill includes the provision for home cultivation as if this was a necessary endeavor to legalize cannabis and make legal consumption available. We categorically believe that this is a misguided portion of piece of the law. But overall, for several reasons, home cultivation within a strictly regulated public health framework is a false romanticization of an idea of what cannabis production and growing should look like, and is misguided from a public health point of view. That was Benedict Fisher, again, senior scientist of CAMH. Constable Mike Sayre, co-chair of the Drug Advisory Committee for the Canadian Association of Chiefs of Police, quote, with respect to in-home production, our members are of the view that realistically we do not have the capacity to enforce nor determine what is illicit and licit cannabis. Additionally, it will provide for additional opportunities for illegal possession, distribution, and overproduction of cannabis. Also, we fear that it will pose a further risk to youth due to increased exposure and accessibility. Rick Garza, Director, Washington State Liquor and Cannabis Board, May 3rd to SOCI. The perspective from law enforcement is, if you're creating a legal market, why do you need to create an opportunity for folks to grow for themselves and possibly sell out the back door? When I consulted with the states of Colorado and Oregon, they said, quote, if I could go back and change something, I would not have allowed for home grows, end of quote. Michael Bourque, CEO of the Canadian Real Estate Association, to SOCI. Indoor cultivation can cause damage that will result in increased expenses, especially for landlords, who will then have to pass on these costs to tenants. This will raise rents for Canadians and disproportionately impact lower-income Canadians. The stated purpose of the bill is to protect public health and public safety, and yet the legislation ignores evidence that growing cannabis indoors can be hazardous to the home and the health of the homeowners. Okay, so I therefore propose to amend the bill to prohibit home cultivation in Clause 8, page 7, that Bill C-45 be amended in Clause 8 on page 7 by replacing line 13 with the following. D, for an individual to possess one, and B, by replacing line 16 with the following. E, for an individual to possess one or more.
Okay, any other comments, Senator Dean?
Yes, on the last clause that we looked at, we agreed that we would recognise the ability of provinces and territories to ban home cultivation under their own provincial or territorial legislation. That's consistent with the overall approach really in the Act, which recognises that that the regulation of home cultivation is delegated to provinces and territories and to municipalities where they will regulate it. All but 2 provinces and territories have landed on the initial 4 plant limit. 2 have decided to go the other way, yet more could theoretically decide to go the other way in the wake of the amendment that was just passed. And I believe that the provincial and territorial jurisdiction to regulate in this respect, and all have, should be respected. Many people grow cannabis at home for personal use already. We've heard testimony that when a small number of plants are grown, the harms that are associated and hazards that are associated with industrial-style home grows are absolutely minimised. We've heard that the risk of children ingesting growing cannabis is close to 0, unlike the high probability that they will ingest laundry pods or other chemicals in the home. Medical cannabis home grow is enshrined in the medical cannabis system right now and has been for some time. The government, in proposing a home grow regime, dialed back to 4 plants, which is low in relationship to US jurisdictions, and gave provinces and territories the ability to regulate it, and indeed provinces and municipalities are regulating it. It's been noted in testimony that Canadians can grow up to 15 kilograms of arguably less harmful tobacco or cigars, not per household but per person, and can brew wine and beer in private residences. For all of these reasons, and particularly given the important and impactful amendment that we made earlier to fully recognise provincial and territorial jurisdiction in this respect, I will strongly oppose this amendment.
Senator Patterson.
Thank you, Mr. Chair. I'd just like to briefly add a few additional comments in support of Senator Seidman's motion. I toured all the communities of Nunavut to consult on the cannabis bill, and I think what I heard is reflective of what may be the situation with many Aboriginal communities in remote parts of the country. Overcrowded, severely overcrowded homes. We've seen this in First Nations homes on reserves and throughout the territories and Inuit regions. People said very clearly that they were concerned that having plants allowed in homes of any size, especially in overcrowded homes with a full range of youth and elders, normalizes cannabis and sends a signal that it's okay to have, that cannabis is okay if it can be grown in one's home. The other points I'd like to make are people were concerned about a fire hazard, about aggravating the already widely present mold problems, about energy consumption, increased energy consumption required by the growing of plants, and by the risk of break and enter. So I want to add those points, which I heard loud and clear from the communities in Nunavut, that this would be a bad move. Thank you.
Okay. All those in favor of the amendment of JS2, please show your hands. 1, 2, 3, 4, 5. All those opposed. 1, 2, 3, 4, 5, 6. That's defeated.
Could I ask for a recorded vote, please?
Oh. Okay, recorded vote.
The Honourable Senator Eagleton, PC.
Nay.
The Honourable Senator Bernard.
Nay.
The Honorable Senator Dean. L'Honorable Sénatrice Meji. The Honorable Senator Munson.
No.
The Honorable Senator Omenfar. The Honorable Senator Patterson.
Yay.
L'Honorable Sénatrice Petitclerc.
Nay.
The Honorable Senator Platt.
Yes.
L'Honorable Sénatrice Poirier.
Oui.
The Honorable Senator Seidman.
Yes.
The Honorable Senator Stuart Olson.
Yes.
Yeas pour 5. Nays contre 7.
So I declare that the motion is defeated. So moving on next to JS3. This relates to page 9 in the bill, and it's a JS now. That's gone. That's true, because it's a consequential amendment. And the same with, well, I'll wait till I get to them. So WTB, that's Bernard, Senator Bernard. On page 10, your motion, please. Please read the motion, and please give us your why behind it.
So the motion reads that Bill C-45 be amended in Clause 9 on page 10 by adding the following after line 3. 2.1 subparagraph 1A2 does not apply. So A, if the cannabis is distributed by an individual who is 18 years of age or older and less than 2 years older than the individual to whom they distribute the cannabis, or B, if the cannabis is distributed to an individual who is 16 years of age or older by their parent or guardian in their dwelling house. So there are 2 points here, colleagues. One is social sharing for those close in age, and this is an issue that we heard many of our witnesses speak about. In fact, as recently as last Thursday, there was a witness who spoke about this. Mr. Tusaw, who was giving testimony as an individual, spoke to this issue. And I just want to quote from him. He says in his testimony, "Let's be clear. I think Bill C-45 takes steps in the right direction by not criminalizing young Canadians for possession under 5 grams of cannabis. You're precisely right to say this close in age issue is a very serious issue." He went on to say, my eldest daughter is 17. Her peer group includes people down to 14 years of age and up to 18, 19, 20 years of age. It is perfectly normal behavior for young Canadians who are 19 to potentially use cannabis and share cannabis with their peers who might be under the legal age under Bill C-45. This bill is attempting to address consequences of a criminal record for simple possession for those close in age but under the legal age, so we're suggesting the 2 years. The reality is that social sharing is very common among teens, and we do not want to criminalize an 18-year-old for social sharing. And it is also quite normal for 18-year-olds, 19-year-olds to have friends that are slightly younger, peers that are slightly younger than themselves. The other point is parents sharing cannabis with their children who are 16 years but under the legal age. We have heard from several witnesses that prohibition has driven people into the illicit market. Parents have the responsibility to parent their children. And they should be able to teach their teens appropriate use of cannabis without fear of criminal penalty. In doing so, their goal would be to teach appropriate use. It would be sharing of a legal substance, not an illicit substance. And it would be known content, so they'd be sharing cannabis with known content. I would see it as being similar to sharing a glass of wine in one's home, parents sharing a glass of wine at dinner in one's home with their 16, 17-year-old children. Those are the reasons why I'm putting forward this amendment.
Thank you. Senator Seidman?
While I understand the general spirit of this, I would say that if we do something as major as this, it tends to normalize and almost trivialize the whole point of what we've heard is behind the legalization, so that if we really want to protect the health and safety of our kids, I don't think we want to serve up cannabis at the table along with a bottle of wine and tell our kids this is fine. I think it's quite the contrary. And I think in terms of criminalizing our kids, we have actually provided a huge amount of insurance by the First Amendment that this committee passed this afternoon. And congratulations to us for all uniting behind supporting additional insurance that our kids are not recriminalized.
Agreed.
Anybody else on this? Senator Plett? Senator Sturgill?
Well, just first of all, I want to agree with Senator Seidman, but just simply to add that we heard from the Parliamentary Secretary today, Bill Blair, that clearly kids are not going to have criminal records for doing this already. He made that very clear, that we don't give them criminal records for many of the other things that they're doing now, and as far as alcohol is concerned, and that they would not be getting criminal records. This amendment legitimizes the fact that we want to legalize already for 16-year-olds to smoke marijuana when we have compelling evidence that we shouldn't even be allowing people under the age of 25 to do this, and we're going down further and further and further. So I, for those reasons, certainly oppose this.
Thank you, Chair. And I listened with quite closely to this one, but this one, I have to admit, really worries me quite a bit. If we're trying to teach people to be responsible and to educate people to be responsible, that does include parents, and it does include older children who you're talking about may share. And I would expect them to behave in a responsible way and not pass on cannabis to kids who are much younger. And I see in there that you've got the limitation, but I think that we have to assume that this is kind of opening the door to, okay, it's okay, you can go. It's the same as kids who give someone a $10 and say, go buy me a pack of cigarettes or go buy me a bottle of wine or something. And they know it's wrong, but, you know, and I'm not saying we can stop it, but I don't think we should encourage it either. So for that reason, I can't support this amendment.
Okay, anybody else? All right, do you want a show of hands or a recorded vote? Recorded vote? Okay, away you go.
The Honourable Senator Eggleton, PC.
Yes.
The Honorable Senator Bernard.
Yes.
The Honorable Senator Dean. L'Honorable Sénatrice Mégy.
Yes.
The Honorable Senator Munson.
Oui.
The Honorable Senator Omidvar. The Honorable Senator Patterson.
Nay.
L'Honorable Sénatrice Petitclerc. The Honorable Senator Platt. L'Honorable Sénatrice Poirier. The Honorable Senator Seidman. The Honorable Senator Stewart-Olson.
No.
Yeas pour 7, nays contre 5, 5.
Thank you very much. That motion is carried. Then we have JS4, which refers to page 12 of the bill, and it deals with a fine amount. Senator Seidman?
Sure. So, the committee heard evidence presented to the Standing Committee on Legal and Constitutional Affairs that penalties for an organization importing or exporting non-medical cannabis or possessing non-medical cannabis for the purpose of exporting are inconsistent with comparable offenses. Bill C-45 allows for the importation or exportation of cannabis only in exceptional circumstances authorized by the Minister of Health, that is only for scientific or medical purposes or for industrial hemp, and this would require a license or a permit. This amendment would raise the penalty for exporting recreational cannabis to the level provided for in the Tobacco Act for tobacco. So basically what we're doing is that we're making the penalty for cannabis, exporting recreational cannabis, the same as the penalty in the Tobacco Act for tobacco. And by the way, this again was a unanimous recommendation from the Legal and Constitutional Affairs Committee from their pre-study and their report to us on Bill C-45. And it's therefore proposed to amend the bill to increase the maximum fine for an organization found guilty of illegally exporting cannabis to $300,000, an amount which is provided for in the Tobacco Act. So, Clause 11, page 12, I move that Bill C-45 be amended in Clause 11 on page 12 by replacing line 28 with the following: more than $300,000.
Okay. Any other comments? Is it Senator Bernard?
I would be speaking against this amendment. I believe that $100,000 is already a significant penalty, and the larger penalty, I think, could disadvantage some people who were falling under that than others. And if it was deemed necessary to increase it after the third-year review, then it could be increased at that time, but I don't think it's necessary at this time.
Senator Platt?
This is for an organization. This is not for an individual. And that organization, if they want to continue to have illegal activities, should be out of business, and we should do everything in our power to make sure they're out of business. This is not for an individual. We're saying if it's guilty of an indictable offense for a term of not more than 14 years, and then to an organization $100,000. If we wanted to be consistent with the 14 years, we'd probably triple that 300,000 yet. So I'm certainly very supportive. Let's make sure that we do not allow commercial organizations and commercial operations to be doing this, and let's send a strong message.
Okay, if nothing else, is a motion agreed to?
Agreed.
On division? Okay, let me take a show of hands then. All those in favor?
Should we have the recorded vote, please?
Okay, recorded vote.
The Honourable Senator Eggleton, PC.
Yes.
The Honourable Senator Bernard.
No.
The Honourable Senator Dean.
No.
L'Honourable Sénatrice Meiji.
Yes.
The Honourable Senator Munson.
No.
The Honourable Senator Omidvar. The Honourable Senator Patterson.
Yes.
Yes.
L'Honourable Sénatrice Petitclerc.
No.
The Honourable Senator Platt. L'Honourable Sénatrice Poirier.
Oui.
The Honourable Senator Seidman.
Yes.
The Honourable Senator Stuart Olson. Yeas pour 7, nays contre 5, 5.
I declare the motion carried. The next one is, in this division, is TD2, which I understand is a technical amendment. I hesitate to use that phrase in case somebody says, oh, nothing's technical here. However, it looks like one. Anyway, Senator Dean?
Safe on this one, other than with my pronunciation. I move that Bill C-45 in Clause 12 be amended by replacing in the French version line 17 on page 13 with the following. N'habit provenant d'un grain ou d'un matière végétal qu'il. And so the reason for this is that it replaces the word semence with grain in paragraph 12.4a in the French version of the bill. Grain is used consistently throughout the bill in describing or translating from seed in all other occurrences. So this was an inconsistency which it is proposed that be corrected.
Senator Seidman?
Sure. Actually, what I was going to suggest, if I might, is that all of these so-called technical amendments or errors in the bill that you're trying to correct, and I think that goes all the way up to through number 29, if I'm correct. Is that correct? That your amendments that you've made to us.
Well, yes. I mean, there are some that are a little bit more substantive when we get to ticketing and replacing.
If you're trying to...
Yeah, there's a mix.
Yeah.
There's a mix.
We'll have to.
Thank you.
Yes, I started to label all the technical ones, but then there's some that are not as technical as others, so. Okay, so is this agreed? Agreed, carried. So JS5 then is a consequence of the previous one on JS3, I guess it was. So it's gone. So that brings me to RO1, that's Ratnam Navar. Okay. Senator Navar.
Thank you, Chair. This amendment comes from witness hearings and stakeholder representations on the unintended yet fairly large and disproportionate impact of certain sections on C-45 for permanent residents. Let me just describe them to you very quickly to give you some context. A number of offences in the Act carry a maximum penalty of over 10 years. For example, Section 9, which is the section that deals with distribution, sets a 14-year maximum for an adult sharing cannabis with a minor. This pushes the offence to serious criminality under the Immigration, Refugee and Protection Act. And by making these offences serious criminality, all permanent residents that are convicted, no matter what their sentence or their penalty, will be inadmissible and therefore could be put into interim incarceration or be deported. This is an unintended outcome that needs to be addressed. The amendment that I am proposing does not change the maximum offense. It just changes the fact that anyone who is convicted for 6 months or less will not be deemed inadmissible as per the Immigration, Refugee and Protection Act. This amendment does not ask for special treatment, colleagues, for anyone, but for equal treatment for those who are convicted and receive a prison sentence of 6 months and under. They should do their time and be rehabilitated, we hope, but they would not suffer the added consequence of deportation, inadmissibility, or the consequence of family separation. By focusing this amendment on those who receive a penalty of under 6 months, the amendment covers not those who are hardened criminals, and certainly hardened criminals who receive a penalty of over 6 months should do their time and face the consequences. This impacts those individuals who may be first-time offenders and who would, in my opinion, not be serious criminals. So the amendment, I propose that Bill C-45 be amended in Clause 15 on page 16 by adding the following after line 31. 15.1, a conviction for an offense committed under Section 9, distribution, social sharing, 10, selling, 11, importing and exporting, 12, production, or 14, use of young person, does not constitute serious criminality for the purposes of subsection 36, bracket 1 of the Immigration and Refugee Protection Act, unless the person was sentenced to a term of imprisonment of more than 6 months in respect of that offense.
Okay, any other comment on this one? Senator Stewart-Olson?
Just a question for clarification, Senator. This, in the previous amendment that was approved, it's for sharing. It would not be a criminal offense. So why would someone who is charged and it is a criminal offense and gets a prison term of 6 months, why would that not? I mean, I don't see them as equal. If you're sharing something and it's not deemed an offense, but now you're coming up into an area where people are actually sent to jail for what they've done.
Of under 6 months.
No, jail is jail.
Or even a discharge. Even if you get a discharge, you are still considered to be a serious criminal under IRPA, and therefore deportation and inadmissibility.
This is very different, though, from the previous one of sharing. This is actually someone who commits the crime, I'm not sure what the crime would be, because it could be anything really under this or under section, but they're then sentenced to 6 months in prison. So I don't understand why you
Your sentence, Senator, you have a valid concern. I too have a valid concern that people who do the crime should do the time. I'm pretty sensible about that. What I'm concerned about is the double penalty that will be that has an impact on only one section of criminals who are sentenced for under 6 months, and that is permanent residence. Everybody else, their life will go on, whichever way they choose to. We certainly hope that after 6 months in prison, they would be rehabilitated and follow the straight and narrow. But at the same time, what we are saying is that lives should not be ruined by an added disproportionate penalty of inadmissibility and deportation.
I see what you're saying, but then the unintended consequence of this is you're now coming over into the Immigration and Refugee Protection Act, which is something I hadn't even considered, but that's going to be something else that they're going to have to deal with, and I'm a bit concerned about that. I mean, this bill does not. We're not doing a special bill or special amendments for special people. I don't think it's fair to come up and do that, because I know.
I asked, so you think it is fair for people?
I think that the Refugee and Immigration Protection Act was designed for a purpose. We haven't looked at that, and I don't think that this committee looked at that under this, so I'm not sure we should include an amendment that comes into, I haven't heard, I don't know if you had witnesses. Did you have witnesses?
We had witnesses. I can quote their witness
Sorry, then,
testimony.
sorry,
I missed that.
Can we keep this down? It's, go to Senator Platt. I think the points have been made on both sides here. Yeah.
Question.
No, I know
and
that.
they
I
had
realize that. We
witnesses.
got into a two-way dialogue here. Senator Platt?
Well, I want to echo again, Senator Stewart. Also, we're dealing with the Immigration Act here. I'm not sure that I'm at all opposed to the intent of what you're trying to do. I just don't think we have the right here to deal with other acts, and I suspect that if we would have a constitutional lawyer in front of us, he would say that we don't have the right to do this here. And maybe Senator Gold, the way he's looking at me, I'm not sure if he's constitutional. But I would be very surprised if the government would accept this amendment. I'm going to vote against it for that reason. Not because I don't identify with what you're saying, but I just simply think we're stepping into an area that we shouldn't be stepping into.
Senator Stuart Olson and Senator Platt, I appreciate your comments. We have talked to the law clerk. This is within the scope of the bill. And this is the bill before us. This is the bill that will have a severe unintended consequence on a large group of people. And that is why I'm proposing we amend the bill as it is before us, as opposed to waiting for IRPA.
Okay, let me call the question.
Senator Pucci-Clay.
No?
Très, très rapidement, un peu pour répondre.
Quite briefly, and perhaps in response to Senator Olson's comment, we have heard witnesses, and the concern was expressed. I wasn't familiar with the issue at all, but various witnesses did bring it forward in various contexts. It came back to the committee on more than one occasion, and I feel fairly confident in supporting this amendment.
Anything they wish to point out in this case, or is this a policy decision entirely?
I think I would agree it's a policy decision. C-45 does not currently propose any amendments to the FERPA.
Okay. All right. So we have, do you want a recorded vote?
I'm okay on division.
Okay. Well, I might need to see a show of hands, though. All those in favor of this amendment? 1, 2, 3, 4, 5, 6, 7. All those opposed? Okay, it's carried on division. Now, JS6, I'm sorry, I was trying to point out before that part of this was covered in 5.1, but not all of it. Anyway, it's your motion, so go ahead.
So this was, and indeed you're right, we've sort of dealt with this in a previous motion, except that, of course, this is dealt with in a different clause.
Cannabis was not in that previous part. That's different.
Right, okay, so let's just go through this. So the committee heard evidence from witnesses and from the Standing Committee on Legal and Constitutional Affairs that home cultivation of cannabis plants could be difficult for law enforcement to enforce, and that home cultivation in general could risk more cannabis being diverted to the illicit market. It was also noted that indoor cannabis cultivation may compromise air quality, increase the risk of fire, and have the negative impact on the value of residential property. 2 provinces, Quebec and Manitoba, have passed legislation to restrict home growing in their provinces. While the federal government has said they will not challenge the provincial prohibitions, there is nothing standing in the way of an individual bringing forward a court challenge, and we've already discussed this. So this particular amendment, though, would set out in law that Bill C-45 does not interfere with the provinces and territories' legislative authority over the possession, cultivation, propagation, and/or harvesting of cannabis plants in designated areas, including the power to prohibit it. And so what it does is, it proposes to amend the bill specifically by creating a new clause, 15.1 on page 16, to specify the provinces and territories' legislative authority over the possession, cultivation, propagation, and/or harvesting of cannabis plants in designated areas, including the power to prohibit it. So now I do move that Bill C-45 be amended on page 16 by adding the following after line 31. 15.1. For greater certainty, this act does not affect the operation of any provision of provincial legislation that is more restrictive with respect to the possession of cannabis or the cultivation, propagation, or harvesting of cannabis plants.
Well, can I just clarify? The last part here, we already dealt with in 5.1. Okay. But this possession of cannabis, what does that entail? You're saying the provinces should have that. Does that in any way conflict with the federal law? I could ask the officials if you like.
It starts out by saying for greater certainty, this act does not affect the operation.
In view of what we've done, I'll ask the officials at 5.1.
Yeah.
What effect does this have? Or is it just a duplicate, or is the possession of cannabis something quite different?
Restricting possession of cannabis, to my knowledge, has not been an issue during committee debates, beginning with the House. So there is a province that has restricted possession in private. So I'm not certain what we would be adding here in terms of trying to clarify the role of the provinces.
I might say, that's my general inclination, is that this is a duplicate of what we've already passed. But the fact is that when the law clerk created this, it was created for a different clause. So it's only to be sure that it does provide the same protection.
Well, so that we're not, so can we call it a duplicate?
Sounds
then?
as we're calling it a duplicate.
Okay, all right. Then let's move on. Then. Thank you. So this brings us to the end of this division. So my question is, shall Part 1, Division 1, entitled Criminal Activities, which contains clauses 8 to 15, as amended, carry? That agreed? On division. Okay, that's carried. So Part 1, Division 2, other prohibitions. And that brings me to JS7 in the amendments. And this relates to page 18. So 18 in the bill. So, Senator Seidman.
Thank you. So the committee heard that youth are at greatest risk from cannabis promotion, which experts predicted will have a pernicious influence as the industry is commercialized. In particular, the promotion via the internet is likely to reach young people, even if measures are taken to ensure that the promotion cannot be accessed by a young person. This amendment removes the exception for advertising by means of telecommunication, where the person responsible for the content of the promotion has taken reasonable steps to ensure that the promotion cannot be accessed by a young person. So we know that age verification measures on the internet aren't effective. We've all seen, you go onto a website, and if you check a box that says you're 18, you can gain access to any promotional content online. I will tell you that the CAMH framework, the task force report, both of which recommended that the government prohibit marketing, advertising, and sponsorship, just a blanket prohibition for cannabis. So the fact is that in this case, prohibiting advertising by means of telecommunication would still give companies plenty of opportunity to differentiate their products in the retail environment in a place where young persons are not permitted by law. And I will tell you that we did have in front of us, in front of the Legal Affairs Committee, Rebecca Jesseman, the Policy Director for Canadian Centre on Substance Abuse and Addiction, who did say, an additional concern I would flag in terms of online is the regulation of social media and other online sources of promotion that we know is already a significant challenge for our regulators in general, for media, for example, policing content regulations, let alone the promotion of controlled substances. There's something to be aware of here. So again, I say that I am proposing here to prohibit the promotion of cannabis by means of a telecommunication, comparable, by the way, to existing restrictions in the Tobacco Act. Exactly comparable to existing restrictions in the Tobacco Act. Clause 17, page 18, I move that Bill C-45 be amended in clause 17 on page 18 by deleting lines 22 to 25.
Okay, other comments on this? Can I ask the officials about this? It's communicated by means of telecommunications. Does that include telephone and stuff like that? And the preamble to this clause talks about informational promotion or branding preference promotion. So I'm not sure the implications of taking this out. We're not just talking about television and radio, or we're talking about a broader field of telecommunications.
Sure, like internet. It removes the exception for advertising by means of a telecommunication.
Can I understand either from Mr. Costin or the justice people about the implications of doing that in terms of the policy, at least?
Sure, thanks, Chair. I guess maybe a few things. So if we understand the purpose of the motion, it would prohibit and eliminate really all opportunities for the digital promotion of, or the use of, even perhaps through telecommunication, things like telephone. I guess I would make a few observations, maybe of use to the committee. I think one, it might be a useful caveat to understand, I think the thrust behind the task force advice around the prohibition of advertising to young people. I think you're absolutely right. They did, sort of assert the need to take very strong measures to limit their exposure to also all manner of prohibitions, and really that was that advice that led to many of the proposals in the bill. I think it's important to remember, though, that there was also a caveat that talked about establishing or achieving the other government objective about creating a marketplace where the adult consumer can have access to fact-based information, not promotional in nature, but facts regarding the purchase of the product that's being sold. And so I think one consequence of the proposed motion would be eliminating that avenue for an adult to have access to those information that would be helpful in determining whether or not to purchase cannabis. And I'm thinking specifically as an example of some of the digital online stores that many of the provincial governments are preparing to launch. And I would make just a final observation around the point that of enforcement. As a regulator currently, our experience has been entirely around the enforcement of promotional rules and the use of online platforms and digital technology. And as you've heard me say before, the medical cannabis regime that exists today rests entirely on the use of online stores for adults and other medically authorized persons to buy cannabis. There are very, very strict restrictions around what type of information a company is allowed to put on their websites. We have a regulatory program that's equipped for enforcing the rules that exist today. It's not to say that it's perfect, but there are regulatory tools that we have at our disposal for monitoring and taking action for these types of rules.
Senator Seidman again on this.
I would just say that I don't think this amendment asks for anything more than the current restrictions in the Tobacco Act. And I would say again that the task force and the CAMH framework both recommended that the government prohibit marketing, advertising, and sponsorship, and they didn't make any exceptions. This would not change the fact that factual advertising would be allowed in retail places where young people are not permitted by law. Would have no effect on that. So all the factual advertising, information, whatever, could be very accessible in retail outlets where young people are not allowed.
Okay, anything else on this? Okay, I take it you're agreeing to this? Are you? Carried. That's carried. Well, I asked if anybody was. Okay, well, let me have a show of hands. Those in favor of this? Pardon? You want a recorded vote? Okay, let's go. No, I've been asked for a recorded vote. Order. Well, I did, but then people said they weren't ready. Did I misread it? So we'll have a recorded vote. Okay.
The Honourable Senator Eggleton, PC.
No, I'm against it.
The Honourable Senator Bernard. No. The Honourable Senator Dean. L'Honourable Sénatrice Meji. The Honourable Senator Munson. No. The Honourable Senator Omidvar. The Honourable Senator Patterson.
Yes.
L'Honourable Sénatrice Petitclerc. No. The Honourable Senator Platt. L'Honourable Sénatrice Poirier. The Honourable Senator Seidman. Yes. The Honourable Senator Stewart-Olson. Yes. Yeas pour 5, 5. Nays 7, 7.
Accordingly, the motion is defeated.